on issue 1, please.
Good afternoon, Your Honors.
Good afternoon.
May I proceed?
Yes.
Good afternoon, Your Honors, and may it please the Court. My name is Eleni Dadian, and I, along with my co-counsel, Nicholas Gooden, will be representing the respondent, Calabasas High School, in the case of Miley Tenner versus Calabasas High School. I will be addressing the Fourth Amendment issue before the Court and arguing that Miley Tenner's Fourth Amendment right to be free from searches was not violated by the school. The respondent seeks the reversal of the 14th Circuit Court for the following 3 reasons. First, Miley Tenner did not have a reasonable expectation of privacy based on a number of factors, including the school's acceptable use policy, the AUP, and the fact that she was using a school-issued laptop. Second, even if this court finds that Miley Tenner does have a reasonable expectation of privacy...
Well, just on that point, so explain to me why it matters that it was a school-issued laptop if she's using a private email service on her own private Wi-Fi network.
Because, Your Honors, when using a school-issued computer to allegedly distribute ketamine to students could severely damage the school environment itself. Your Honors, when students transfer from a physical to a virtual environment, the school environment does not disappear. Now, for students, especially for Miley Tenner, that school environment now exists on the school-issued computer. Therefore, if any misconduct occurs...
Let me ask you a question. I'm sorry to interrupt you, but it just occurred to me. What if everyone was in school just like things used to be, and someone is in the school using data? Or no. Let's say the school provides Wi-Fi. They're using Wi-Fi from the school in the school to get private email. Do they have an expectation of privacy there?
Would the student be using a school-issued computer, or would it be their...
No, using their own phone.
Well, of course, Your Honor, the student would have a reasonable expectation of privacy because it is their own device. What the biggest factor...
Even though they're on the school Wi-Fi and in the school, because you told me those were very important. You said the school environment was important to her home.
Yes, of course, Your Honors, but students would not be using their phones to conduct educational activities. What's different from the hypothetical that you mentioned in comparison to the case at bar is that the biggest fact here is that Miley Tenner was using a school-issued computer, whereas in the hypothetical, she was only using, she would be using her phone. And even though she would be connected to the school network, using any sort of school-issued technology where the school environment is now located could severely damage the actual school environment for herself and for other students.
The problem is, I think, in the wording of your policy, there is no expectation of privacy for devices connected to the school internet. Once she got that device home and was using her own internet, it seems to me a clear reading of your policy would suggest that she did have an expectation of privacy. She was not using the school internet.
Yes, Your Honor, that is true. However, there is another essential guideline in the AUP that states that students should adhere to the same standard of conduct as if they were in the classroom. So what the AUP is suggesting is that even if students are not located in the classroom itself, does not mean that the rest of the AUP guidelines don't apply. But Your Honors, the AUP is but one factor as to why Miley Tenner did not have a reasonable expectation of privacy. The fact that...
Counsel, I'm sorry, before you move off of that, I'm trying to understand what devices connected to the school network means now in the AUP. And does it mean that a device that's connected to the school's Wi-Fi network, or does it mean devices that are connected to like an intranet that the school might use within the school boundaries to provide educational resources or materials for the students? Because obviously an intranet and a Wi-Fi network are very different things.
Of course, Your Honors. The AUP doesn't specifically state whether it's the Wi-Fi. However, the network that Miley Tenner would have been using if she was in the school cannot be located at her home. So she most likely was using her own Wi-Fi, but that does not matter. It does not give her that reasonable expectation of privacy because schools do stand in local parentis for students, to not just for custodial concerns, but also to maintain a proper educational environment by upholding school rules. Therefore, Your Honors, even though Miley Tenner was not connected to the school network, it doesn't immediately translate to her having a reasonable expectation of privacy. Furthermore, Your Honors, even if there was no AUP...
I'm sorry, counsel. I'm still not sure what connected to the school network means, and if it's that vague, then doesn't that vote against your client? That if in other words, the restriction on the AUP, which does not specifically extend outside the school physical structure, but if the restriction of the AUP is limited to devices connected to the school network and nobody knows what that means, then how can anybody expect that there may be an intrusion into their personal device?
Well, Your Honors, the AUP is, even if there was no policy, this does not immediately translate to Miley Tenner having a reasonable expectation of privacy.
Wow.
In O'Connor v. Ortega, this court stated that in the absence of a policy, this does not immediately translate to an individual having a reasonable expectation of privacy. Therefore, even if there was no AUP, it would not have immediately translated to Miley Tenner having a reasonable expectation of privacy. But Your Honors, even if this court finds that Miley Tenner does have a reasonable expectation of privacy, this court must determine whether the search was justified at its inception and whether it was excessive in scope. To address the first prong, when Ms. Smith addressed concerns to Principal Liu in regards to interactions between her son, Caden Smith, Miley Tenner, and other students, Principal Liu was obligated to search into the matter further in light of the school's record in the past, where just 4 months ago did the school see a spike in suspensions, expulsions, and other drug-related incidences. Your Honors, the concern that Ms. Smith brought up was extremely credible. Not only was it specific in that it directly mentioned Miley Tenner by name, but it also was persuasive because not only was she implicating Miley Tenner, but also her own son, Caden Smith, as well.
But why wouldn't the principal bring the parent and young Miss Tenner into the school and discuss informally what his or her concern is before reading, over 100 private emails?
Well, Your Honors, unfortunately, there was no school. It was devastated by an earthquake. But even if they did a virtual meeting, it could have been possible. Your Honor, there are always alternative ways in which a governmental institution can go about achieving their interests. But it wasn't necessary for Principal Liu to conduct an interview because the allegations that were brought against her cited that she completely disregarded the rules in the AUP, that she didn't even use this for educational purposes, and instead used them to distribute ketamine to students in the school.
So with the information that the principal had from Ms. Smith, could the principal then have looked through any online bank accounts that may have been resident, or the passwords may have been resident on the borrowed school laptop to see if there were questionable financial transactions, or to go into Ms. Tanner's personal medical records if the password was stored in the web browser to see if she was receiving treatment for any drug-related or drug type of side effects?
Your Honors, looking through medical records is extremely invasive and far more intrusive than looking through one's private email. But the emails that...
I can't say I agree with you on that. I mean, our personal devices today have our most intimate, private thoughts and actions on them. I think that what was done here was pretty intrusive.
Your Honors, this court has ruled in favor of other governmental institutions where the intrusions were far greater than the one in the case at bar. For example, in the city of Ontario versus Kwan, there was a search that was conducted on a government-issued pager where 456 text messages were searched, some of those being sexually explicit. And despite that fact, this court still ruled in favor of the Ontario Police Department because of the legitimate governmental interest that the Ontario Police Department had to ensure that the police officers were not going to be misusing their government-issued pagers. Furthermore, in Vernonia v. Acton, there was also an incredibly intrusive search where there was urine testing that was occurring. And despite that intrusion or that search of urine, this court still ruled in favor of Vernonia, of the school, because that school was also facing an eerily similar drug problem as to the one that Calabasas High School is currently facing. Your Honors, at the time, Calabasas High School was not only...
I'm sorry, can I take you back to one of your case examples? Because with government-issued devices, which my colleagues and I are somewhat familiar with, and there's always a limited personal use notification given ahead of time that this is a government device, limited personal use. And I think we all accept those with the expectation that Big Brother may be watching and may be able to go into, judges excluded, but other court employees may have their emails read, reviewed, monitored. Part of my concern here is that there's nothing in the record, it would seem, that Ms. Tanner was told ahead of time, do not use this laptop or anything other than X, or we may be reading your emails, searching your bank records, looking at your medical files. It shouldn't have been incumbent on the school to give some sort of specificity to the limited use exception for the laptop.
Yes, Your Honors, and the school did. They ensured that students would be aware of what the AUP stated, not just on the first day of school via flyer, but also on the shared drive where other essential protocols such as the virtual learning platform were located. Your Honors, I acknowledge that my time's expired. May I have a brief moment to conclude?
Of course.
In order to provide stability and relative normalcy for its students, schools must be given the deference to maintain a proper pedagogical environment in both a physical and virtual atmosphere. For these reasons, we ask this court to reverse the 14th Circuit's Fourth Amendment decision and rule in favor of Calabasas High School. Thank you.
Thank you, counsel. We'll now hear from